Judgment in the appeal, the Queen against Varma.
Lord Clerk will give judgment.
This is yet another appeal under the Proceeds of Crime Act 2002, the 2002 Act, which has taken up so much of the Court's time in recent months. On the 24th of October 2007, and again on both the 3rd and 13th of April 2008, the respondent, Mr. Varma, was stopped at Gatwick Airport and found to be in possession of a quantity of tobacco which he'd brought into the United Kingdom without having paid import duty. He was subsequently convicted in the Crown Court of being knowingly concerned in the fraudulently evading duty, contrary to the relevant provision of the Customs and Excise Management Act 1979. On the 15th January 2009, the judge made Mr. Varma subject to a conditional discharge for 2 years under Section 12 of the Powers of Criminal Court Sentencing Act 2000, the 2000 Act. Confiscation proceedings under Part 2 of the 2002 Act were postponed until the 3rd April 2009. On that date, the judge made a confiscation order depriving Mr. Varma of the profits of his crimes to the extent of the amount available for recovery. The judge valued that sum at £1,500 and made a confiscation order in that amount. On the 13th of July 2009, Mr. Varma sought leave to appeal out of time against the confiscation order on the basis that there was Court of Appeal authority, namely the Queen against Clark, which had recently been decided, to the effect that the Crown Court has no power to impose a confiscation order against an offender following conviction for an offence in respect of which the offender has been absolutely or conditionally discharged. The Court of Appeal granted permission to appeal, allowed Mr. Varma's appeal, and quashed the confiscation order, holding that it was bound to do so by the decision in Clark. However, the Court made clear that, but for the decision in Clark, it would have reached the contrary conclusion and allowed the confiscation order to stand. The Court of Appeal certified this question for the consideration of the Supreme Court. Does the Crown Court have power to make a confiscation order against a defendant following conviction for an offence if he or she receives an absolute or conditional discharge for that offence? The Supreme Court unanimously allows the appeal. The Crown Court has the power, and where the criteria in Section 6 of the 2002 Act are satisfied, the duty to make a confiscation order against an offender following conviction for an offence in respect of which the offender has been absolutely or conditionally discharged. I gave the leaving judgment, with which Lord Dyson and Lord Reid agreed. Lord Phillips and Lord Mance gave short concurring judgments. The reasons were shortly these. Where the criteria in Section 6 of the 2002 Act are satisfied, the Crown Court is not only empowered to make a confiscation order, but unless it believes the victim of the conduct has started or intends to start civil proceedings against the offender for loss, injury, or damage arising from the conduct, is under a duty to make such an order against the offender, even where the offender has been absolutely or conditionally discharged following conviction for that offence. Those criteria are satisfied in this case for these reasons. A, Mr. Varma was convicted of offences in proceedings before the Crown Court. B, the prosecutor requested that the court proceed under Section 6. C, the Crown Court held Mr. Varma had benefited to the tune of £7,257.86. And D, the court decided upon the recoverable amount, which it valued at £1,500. Consequently, the court was under a duty to make a confiscation order in that amount, even though Mr. Varma was conditionally discharged. There is nothing in the Act which gives the court the power to decline to exercise its duty to make a confiscation order where the criteria in Section 6 are satisfied. The purpose of Section 13, subsection 4 of the 2002 Act was neither to prohibit nor to limit the scope of a confiscation order. The reference in that section to, quote, deciding the appropriate sentence for the defendant referred to the sentencing process during which the court considers how the defendant should be dealt with. It's unnecessary to decide whether an absolute or conditional discharge constitutes a sentence for these purposes. It is sufficient that an absolute or conditional discharge is an order made as a result of, quote, deciding the appropriate sentence within the meaning of section 13, subsection 4. Sections 14 and 5 contemplate circumstances in which confiscation proceedings may be postponed until after sentence is imposed, but such a postponement of confiscation proceedings in no way nullifies the court's duty to return to those proceedings after deciding upon the appropriate sentence. The court acknowledges that there's no express reference to confiscation orders amongst the measures the courts are not prevented from imposing under section 12, subsection 7 of the 2000 Act, where an offender is absolutely or conditionally discharged. Nonetheless, the court holds that the lack of any express reference to a confiscation order in section 12(7) does not nullify the duty on the court to make such a confiscation order where the criteria in section 6 are satisfied. Lord Phillips gives a short concurring judgment in which he questions, obiter, whether it is legitimate for the customs, as the prosecuting authority in this case, to seek a confiscation order rather than seeking to exact the duty payable on the goods. He questions whether in confiscation proceedings it is legitimate to treat a defendant as having evaded duty where the only reason he has done so is that the customs have chosen not to exact it. Lord Mance gives a short concurring judgment on the principal point, but expresses doubt on Lord Phillips's point. In the result, the appeal is allowed and the confiscation order restored.
The court will now adjourn.